Hello, everybody. So, today I am going to briefly tell you what will be my strategy for the course which you all will be enrolled in. So, most of the academies call it as a demo class, but I am here. See, it's not a academy where you are paying fees and you've been charged for giving particular knowledge of a particular subject. I am Rinipal Chima. My initial qualification is BCom Honors with LLB, Masters in Law, and I also do outsourcing work in UK, also reading the English law simultaneously. Friends, first of all, I want to clarify doubts, if any, regarding the functioning and the process by which I will be discussing the important aspects of law. As a lawyer, as an educationist, I have an experience of almost 18 years. I've been practicing initially in the trial courts of various districts, starting from Chandigarh, covering some important districts of Punjab, Haryana, even in Delhi also, especially the courts of CBI. Then I had a privilege of practicing in not only of High Court of Punjab and Haryana, but also Delhi. I have also appeared in Honorable Supreme Court. As Socrates say, that the highest court of the land is the land where people come with their expectation. Because for us, equity is a very important aspect of law. As you all should be aware that in India, civil courts are also courts of equity. Vis-a-vis, when I talk about UK law, courts of equity are different. So I am here to assist you. You are all my worthy associates. I have been into this stream almost, I think, since I've done uh, almost, I think I started immediately when I did my master's in law. I was giving free lectures. Then I also had an opportunity of working with my worthy colleague who was a topper in the Punjab judiciary at the district level. He was topper in Delhi also. He was elected as a ADJ. And I remember that we both used to gain experience with the knowledge we were imparting to the worthy candidates. So it's more of a law relating topics and the discussions which I will be discussing with you. We are not going with any kind of a principal application like, all right, see, understanding of procedural and substantive law is important, not only for candidates who are appearing for judiciary, but also for lawyers, for educationalists and paralegals. As we say, excuse of law is no excuse. So understanding the basic concept, because at this level, when you all are preparing for your career also, because knowledge, I believe in this principle that knowledge is the biggest investment. God has been very kind. I have always had the liberty and wisdom was prevailed by my mentor that if I have the resources, education should be free, as it is also envisaged in our Constitution of India, right of free and compulsory education. So we all are learners. I have experience of candidates in Delhi, Haryana, Punjab, despite of not advertising, despite of not making it commercial, my one of the candidates, Charanjit Kaur, who was the topper of UILS 5 years, she cleared the JAC, the army tribunal courts in the first attempt, the moment she passed law from 5 year Punjab University. In her first attempt, she also cleared and cracked the Delhi judiciary. Similarly, when I talk about district judges, I had the privilege of giving my valuable inputs to one of our very learned advocates, Advocate Sibia from our Punjab Haryana High Court. Now, Madam is posted as a district judge in Gujarat. Few of my candidates are also in Punjab and Haryana, Rajasthan. One was one one of my candidate was uh, into judicial services, and he then, after 5 years of practice, in today's time, he's a successful barrister in Canada also. So, what I am trying to tell you that once you all do law, we have certain presumptions. We follow the mad race. Most of the candidates, unfortunately, without understanding that for practice or for being a presiding officer, you need to understand the basics. See, age is a very vital factor. And there are three stages of being a judge. A, if you crack a if you crack a judiciary exam at the lower judiciary, like civil judge. Now, this is being advertised by the states like Punjab Judicial Services, Haryana Judicial Services, Himachal, and Delhi. But you all should be aware that Supreme Court is now hellbound. They want to have one. Supreme Court is also trying that there has to be one. Even the government is trying. There has to be one judicial examination for everybody. And I tell you, nobody would have ever told you that there was one of the landmark judgments of the Supreme Court, which was it where it was held. It is mandatory for the law students to go through 3 years training practice in the advocate for 3 years. Eventually, it was challenged, but finally, the Supreme Court held that 1 year training is compulsory in the Judiciary Academy. Judicial Academy, like Chandigarh, we have a Chandigarh Judicial Academy in 43. I had a privilege of visiting that academy and doing some interactive sessions with the candidates there. So I also tell you that that academy is not only catering to the candidates of Punjab, it is also catering to the candidates of Haryana. Similarly, Delhi has a Delhi Judicial Academy. Then we have a Pioneer Academy in Bhopal, National Judicial Academy. So these academies are imparted with the job of training to the young lawyers who have cleared the judiciary exam. So just cracking the judiciary exam will not solve your purpose. Again, you have to go for 1 year rigorous training. So here we are here to, so here we are to discuss the different facets, different aspects of law. We have to understand basic principles of law and to test ourselves with the latest law as held by Honorable Supreme. As you all are aware, that Honorable Supreme Court judgment is the law of the land. So you all must be aware of article. Now I will not name the article, but you should be aware there is one article in Constitution of India which says law of Supreme Court is the law of land. But my dear friends and colleagues, I must tell you here also, when you read a judgment, you should always read a constitution judgment because constitution judgment is the uh, uh, highest level of bench of the Honorable Supreme Court. It is like constitution bench judgments. Normally we say five or more than that. It is a constitution bench. Then we say full bench reference, where there can be three judges. Then we say in Supreme Court, you all be aware there is no single judge. There is always at least a division bench which gives a judgment in the Honorable Supreme. So whenever you read law, you should must interpret in the way it has to be that meaning is to be imparted to the law students. See, our law is basically written in Latin language. It is like your maxims, res judicata, res espa luxure, right? So all these words which I am using, these are basically ratio descendi. These are all Latin words. So first you should understand the meaning. We should all know how to read in between the lines. For reading in between the lines, interpretation of statues is very important. There are basically principles of interpretation. You should all know what is golden rule, what is mischief rule. And when I talk about civil law in particular, you all should know what law of equity is. Now, you see a recent Punjab judicial examination. There is a question on equity. I've been always discussing with my fellow candidates who were attending the lectures that equity you cannot ignore. Your law of contract, your law of specific performance, your law of Transfer Property Act, your rent law, your contract law, Sales of Goods Act, evidence, Sales of Goods Act, more by or large, they're based on law of equity. What is equity? So whenever we start law, we have to first now, suppose I am here, I tell you that I tell you that, okay, we will have a session tomorrow. But I tell you what session, what will be there in the session. So as a law student at this stage, you are bound, it is a bounden duty of each and every candidate at least to read that provision. Just don't come with, you know, without reading a provision. Suppose I am discussing with you section 11, that is res judicata of CPC. So whenever that lecture has to be discussed, A, you should know, you should read the bare. You have your, how do you do research? First, you read the bare act, then you interpret each and every ingredient embedded in that section, and then you read it from the Bible of that particular subject. For example, CPC. So you don't have to go with your, like in college or in your university, you just open up standard book and read it and answer it. No. Here you will read the different facets of res judicata. So there are encyclopedias, the Bibles. So the best book to refer for civil procedure code is one of Mullah's CPC. If you don't have access, I always welcome all of the candidates to visit the library of my office. Otherwise, if they are very far off, they can go to any library of any of the good uh, district courts and you will find that book there. Then you must read the illustrations. This is how we learn. It cannot simply, you will be given notes and you just read it and mark it and you go to the judiciary. No, sorry. I always pray for each and every candidate, whatever you choose, always have options in life, starting from A to Z. We all are learners. You practice also, you learn law also. But at the same time, the key is regularity. Don't just go to the academies for the sake of it and waste money. I am here. We had the results. We will be having the results of the candidates who have worked hard and today they have achieved their respective goals. I simply want your cooperation. I simply want you to educate all your fellow friends who are interested in reading law and understanding law. I don't give you any guarantee that you join my academy, you will be a judicial officer. I will be a fool if I say. But I guarantee one thing, you learn it along with me. We both are learners, but one day, very soon, you will be a very successful lawyer, maybe an educationist, maybe a judge. Give yourself options. And this will not only help you in sky is the limit. See how it makes the difference. You see so many lawyers in the courts, only few of them get relief. How? Because of their understanding of this. So here I am to help you to understand the subject, to read it between the lines, and to give you the latest judgments, the interpretation of it, what our Honorable Supreme Court or what our various high courts have said. If you are focusing on the Punjab Haryana exam, I will be focusing on the judgments of a relevant subject of that Honorable High Court. If you are focusing in Delhi, I'll be discussing the honorable judgment of Delhi High Court. So, for example, in my demo class, like I have to discuss CPC. Let us say that we have done uh, basic, just assume for a while that I assume for a while that you all know the basic concepts of CPC. So I will then discuss with you the different judgments of Honorable Supreme Court, where the interpretation, for example, we start with res judicata. Now, res judicata is section 11. So whenever I talk about res judicata, I will mention section 11. So whenever I read section 11, so you read in the Bail Act, it normally says which matters are directly in issue and which matters are only collaterally or incidentally in issue must be determined on the facts of each case. So when I say must be determined on facts of each case, I will quote a judgment. Obviously, I will quote a judgment of Honorable Supreme Court because in that I remember there is a very famous judgment of Honorable Supreme Court of Oriental Insurance Company versus Tej Paras Associates and Exports. So in that, the apex court held which matters are directly in issue and which are only collateral or incidentally issue must be determined on the facts of the each case. So in deciding that question, the court has to examine the plain and the written statements filed by the parties in the earlier case, issues framed and the judgment rendered by the court in the earlier case. So all these documents have to be produced for invoking the doctrine of res judicata in a subsequent case. So similarly, when I discuss concept of res judicata, I might also touch with you Order 2, Rule 2 of CPC, where it bars the institution of fresh suits in respect of portion of the claim omitted or deliberately relinquished in an earlier suit. So here, I am not only discussing section 11 with you, I will also discuss with you Order 2, Rule 2, CPC, which tells you that which bars institution of fresh suits in respects of a portion of claim omitted or deliberately relinquished in the earlier suit. So when I talk about this, I will again give you a landmark judgment of our Honorable Supreme Court. For example, there is a very famous judgment of Honorable Supreme Court, B. Santoshama versus D. Sarna. So again, I will quote this with you whenever I discuss this with you. And similarly, I will be also propounding on various clauses of res judicata. For example, subsection 1 requires that plaintiff to include whole of the claim that he's entitled to in the suit when we talk about order to rule. So here also I will propound the meaning of rule. Uh, I'll propound the meaning of subclause 1 with the honorable judgment, which is the latest or which is relevant in that particular provision. Similarly, moving forward, I will talk about pleadings in CPC. Now, pleadings, you see, fortunately, you're getting a whenever you talk about level of examination, I tell you Delhi is the toughest of all. So when I talk about pleadings, even when lawyers come to me or my fellow colleagues come to me, the first thing is the pleadings. You should know what pleadings are. Pleadings is the nucleus of CPC. If you don't know what pleadings are, sorry, my friends, you will not be able to understand what pleadings are. So whenever I talk about pleadings, I will talk about Order 6, Rule 17 of the CPC, where the court has the power of amend the pleadings. So in what circumstances amendment is allowed of the plain or maybe the written statement? Because in pleadings, everything comes. Plain comes, written statement comes. And you see a lot of litigation is in different high courts when the amendment of plain or written statement is sorted. So it is always challenged by way of civil revision in our Honorable High Court. So you should know what civil revision is. So this is how we understand the different aspects of civil law. If I elaborate more now, since this is a demo class, but I want to tell you that my approach towards the subject will be simpliciter along with the best of the knowledge of my I have attained. Plus, I will be also giving you the latest judgments, which will not only make a difference in your understanding the subject, but also in achieving you the required results. For example, when I talk about production of documents by defendant, I will talk about Order 8, Rule 1A CPC, where the defendant has to produce documents upon which he bases his defense at time of presenting the written statement. So if that documents are not produced, what are the implications at the time of filing of the written statement? The court has discretionary power under sub rule 3 of order 8 to grant leave to produce them later. So this is very important. If the party is not able to produce the documents under rule 1A of order 8, further there is a proviso, there is a rule, sub rule 3, which allows them to which allows the court to grant leave to produce them later. So where it has been held, I will again tell you the judgment of the Honorable Supreme Court in Sagwandi versus P. Rajkumar, where the apex court held that the discretion conferred upon the court to grant such leave is to exercise judicially. Again, I repeat, is to be exercised judicially. There has to be reasoned order. Moving further, I will talk about rejection of plaint, wide order 7, rules 11. So whenever I talk about rejection of plaint, I will always elaborate on order 7, rules 11 of CPC, which provides for rejection of plaints at the threshold or in later stages in certain cases. It is a special remedy. So likewise, I can always elaborate on the scope of the suit. I can always elaborate on the attempts to produce evidence in the absence of necessary pleadings, because sometimes the lawyer omits to uh, plead the necessary pleadings. So what are the attempts to produce evidence? That all has to be broadly and widely understood by you as a student of law, not only for judicial purpose, but also as a lawyer, maybe an arbitrator, maybe a mediator. So these are the basic wide principles which are very, very important for all of you to understand. Similarly, when I talk about parties, I will always talk about determination of legal representatives and their LRs and their effect there. So always, so similarly, we'll talk about same interest, proper party, necessary party. Then moving further, first appeal, second appeal, now regular second appeal. Always remember question of law is involved there. So when I do a RSA in the Honorable High Court, I have to read all the record. Only if I am able to make substantial question of law. And if both the courts, the trial court and the first appellate court is against me, it is very tough in the RSA to make this impression on the Honorable High Court. Yes, the miscarriage of justice is there. But how is this possible? Only when you read the evidence, only when you read the pleadings. So here, again, the discretion of Honorable Supreme Court is there. And there are landmark judgments on this, starting for Nazir Mohammed versus J. Kamla, where the apex court articulated its views on substantial question of law, where it said a question of law must be debatable, not previously settled by the law of the land or any binding precedent, and must have a material bearing on the decision of the case and or the rights of the parties before it if answered either way. Similarly, when I talk about locus to file appeal, I will talk when can person who was not a party to the suit file an appeal against the decree passed in such suit arose for consideration. So here also, I will give you the judgment of one of the landmark judgments of Honorable Supreme Court of Krishna Murthy's. So this is how my approach to the subject will be, elaborating the different wide aspects of that. Because here only the basic knowledge is not sufficient. You need to understand, give yourself time, give yourself a disciplined, you know, time slot and be regular to it. So regularity is the core. I have to inspire you. You guys have to inspire me. So this is one of the demo classes which I have specially made for you guys so that it gives you more confidence and you should know what you are getting into it. I tell you, it's very tough to give free education, but I do it. It is my bounden duty. It is my passion. It is my tribute to my late worthy father, late Atma Singh Chima, who was the most honorable and the one of the very senior advocates of the Honorable High Court. So I want this via this mode. It is a tribute to him, and I do justice. I should also tell you that I was very lucky that Shrimati Kiran Kher in 2018 on the law day, the district court standing with the help of the law day, along with the district courts, organized a facilitated function, a function to honor me for my extra activities towards the lawyer fraternity. So I want that to continue, and it is my bounden duty to help you all to achieve your goals. I again request you, if you are joining, if you are serious, you should be serious enough. You should give yourself time and try to get maximum out of the discussion. So this is all for one of the versions of my demo class. If you have any doubts, you have my email. You can contact me, and likewise, we will continue the lectures as and when I intimate. My regards, all the best. Even you don't join the this free judicial group, my blessings and wishes will always be there, and I will always be there to assist you. Kind regards, Sat Shri Akal.